According to this, to the hearing notice, it says reasonable accommodation to modify the approved site plan. The so-called approved plan no longer exists because it was appealed. The subdivision plan was appealed, so it was never filed. There is no approved plan. That plan is still under appeal by the citizens. The subdivision plan never went forward. So there is no approved plan.
As a planning board, you approved two plans back years ago. One was a site plan, that was not appealed. The other was a subdivision plan, that was appealed. We'll be coming here tonight into the Zoning Board of Appeals on the 18th. We told her that if the reasonable accommodations were granted, it would moot the subdivision appeal because we no longer would need the subdivision plan to vest our rights under the old zoning.
Okay, thank you, that's great. That's the clarification that I wanted. So that plan, the so-called approved plan, had a subdivision on it, totally different septic system, and they're asking to come in to modify that plan. Anybody can look up what the word modify means, and the word modify means to change something in a small manner, in a small way. This is a major change. They don't even meet zoning. And that's my other question, is I'd like to know what jurisdiction that this board has to waive zoning. My understanding of site plan review is to help an applicant to come into compliance with zoning. Under procedures, section 3.4 of the bylaws, a site plan review, and it says one of the provisions is F, compliance with all requirements of the zoning bylaw. And this board is reviewing this case and are going to allow it to go forward, and it's prohibited. So you're going to approve a site plan that does not comply with the zoning bylaws. You can do that. You have the authority to do that.
We have the authority to give a waiver if that's what we feel that we need to do. Yeah, we have the right to do that.
No, yes, you can waive certain things, but you can't waive the bylaw. It's not your jurisdiction to do so.
What bylaw are we waiving?
It's a prohibited use in that district. They no longer have a subdivision. The subdivision is what grandfathered this lot. That's gone under this plan. There is no more subdivision on this plan. They're no longer grandfathered. We all know that we all take an oath to uphold the bylaws of the town. Before anything. And that's all we've ever asked, is we want the bylaws upheld in this town. That's it.
Thank you, Mr. Chairman. Jonathan Silverstein, Town Council. And I'll just note that in the federal court litigation, the town is being represented by Insurance Counsel, which is the law firm of Brody, Hardoon, Perkins, and Keston. Jeremy Silverfine from that firm is here as well and can answer any questions. Since they're defending these discrimination claims, some of this may be more appropriate coming from them.
Is we want the bylaws upheld in this town. That's it.
Again, I'm not counsel for the town in that case, but just being familiar generally with when cases get removed from state court to federal court by a defendant. So here it was Mr. Silverfine's firm removed the case that Mr. Bobrowski filed in state superior court. There's a provision in federal law that says if the claims involve federal questions, then the defendant, in this case the town, has the right to remove that case to federal court.
Is we want the bylaws upheld in this town. That's it.
So yes, there are two lawsuits right now. There's the subdivision appeal, which was brought by a group of neighbors. And then there is the federal court discrimination case. It is the federal court discrimination case that is making me want to be careful about what I say so as not to increase the odds of a large financial judgment against the town. The residents' appeal of the subdivision approval doesn't carry any monetary damages. So, and frankly, as town council, that is, I have the appearance in the case.
Is we want the bylaws upheld in this town. That's it.
As town council, I have been taking what is called a passive role. I'm not actively defending the subdivision approval. I have left it to Mr. Bobrowski to actively defend that approval since it benefits his client. So I'm less concerned, frankly, with the subdivision appeal because if the town loses that case, all that means is that the subdivision approval gets overturned.
Is we want the bylaws upheld in this town. That's it.
Public hearing was closed. 4-0. You want to do that now, or you want to make everybody wait till 11 o'clock, like they're gonna make me? Okay. Conditions shall be required at the applicant's sole expense unless otherwise noted. The project shall obtain approval pursuant to and be constructed and operated in accordance with all applicable laws, local, state, federal bylaws, statutes, ordinance, rules, and regulations.
Is we want the bylaws upheld in this town. That's it.
Take a motion to accept the conditions as amended.
So moved.
Second.
All in favor? 4-0. Okay, that does it. Thank you, everybody. Four zip. We all did.
Right here. I voted yes.
We all voted yes.